My name is Tommy Ruke. I am the founder of this foundation, and I'm the education director for the Transportation Risk Specialist Education Program. My father was a trucker. I've been involved in the transportation industry for a number of years. For you who do not know my history, my father was a trucker. His primary business at the end of it was hauling pickles for Vlasic Foods. So he was a pickle man, and I was the son of the pickle man. I've been providing education concerning the motor carrier industry to professionals who provide services to motor carriers for over 30 years, and we started this foundation to expand our ability to provide education not only to the insurance industry but other people who are providing services to the motor carriers as well as motor carriers themselves. These programs are designed to educate the insurance industry with information on the ever-changing involvement a motor carrier operates in. And for you who are listening in who are motor carriers, you understand how this is an ever-changing, and we're dedicated to keeping the providers of services to motor carriers current in those areas. Beth, I need to change that. The TRS does provide a designation for you who are motor carriers. You might be looking for these. These insurance professionals who have completed a series of educational programs, have provided service to the motor carrier industry, and who are dedicated to keeping update on the operations and needs of motor carriers. They are granted a designation. These are insurance professionals who have equipped themselves to provide services to motor carrier beyond just delivering the policy. A motor carrier will find benefit in developing relationships with these professionals. For you here who want more information concerning the foundation and the designation or other services that we can provide, please contact us at our webpage, transportationriskspecialist.com, or at our 800 number, 800-741-4084. Crashes happen. Our discussion today will be what should a motor carrier do when it happens. These are suggestions to make this undesirable event less stressful. Be prepared to achieve a good results of an outcome as possible. This is the whole purpose of this. Ideally, a motor carrier's life, there will not be an accident. But history shows us that for every 425,000 miles or so, a motor carrier will have an accident. Like all sound business practices, the best result comes from preparation. We look at some different accident types, and I just want to distinguish this because the actions taken and the needs depend on the severity of the claim or the crash. The accident could be damage only to the owned vehicle. It could also include damage to cargo. In other words, there's no third-party damage involved. That's an accident that would be there. Typically, there would be less exposure from a liability standpoint. There could be a loss of assets, meaning damage to the vehicle itself, that the motor carriers would be concerned about. We could also have damage to other persons or property. This is where there could be increased liability and increased dollars paid out, and these are the concerns that we would have to take the most prevention, so at the time of possible claims, we're prepared to defend the motor carrier and to pay out no more than what is required. When we look at crashes, we also have to determine who was at fault. At fault typically is the action by the driver. In the legal system, they're called the tortfeasor, the person who caused the accident. The motor carrier could be named in the case as contributing to the accident, again, and or causing the accident. These are trying to determine who was the person who caused the damages. You also hear the term not at fault. When it's a not at fault accident, this is when somebody else or some other circumstances caused the accident. And basically the argument there, the discussion there is the accident was unavoidable. But let's look at the accident. At time of accident, it's hard to determine who's at fault. Not always easy to determine the amount of damages. So when we look at those things, we have to make sure that we treat the accidents, no matter how severe we think it might be, nor who caused it, in the same manner. So what we're suggesting here is to have requirements and to need to take all accidents, crashes seriously, and have a standard operating procedure for all accidents, no matter who's at fault and no matter how severe the accident might be. This is the best groundwork. The standard operating procedure needs to be formalized and needs to be communicated to the driver as well as the management personnel of a motor carrier, either through the internal operations of the motor carrier or through their insurance agent to provide help for them in this area. The big part of this is starting with training the driver. It's our suggestions that these suggestions that we have here today would be a part of the handbook. This needs to be discussed during the introduction sessions when we hire the drivers, what is expected of them. It also needs to be revisited throughout the year, at least once a year. Again, to use this as a part of the training program, either through a video that you can repeat again, and this will be available to you, or some others to remind the driver of what they need to do at time of an accident. You also need to keep this material updated and current. Again, I do not have to tell you who are involved in this industry that the government changes their regulations on a repeated basis, and anytime there's a government change and a new government requirement, then we also will make sure the material that we're using is updated. One of the suggestions that we have in this way is anytime you produce a handbook or produce this time material, you put a date on the bottom of it so that we will know, and even in court cases, the attorney will know what the time frame was when these items were published, and that way you would also be able to get rid of the old and replace it to the new easily. So we want to time date everything possible. So that's the driver training. Make sure they're aware of the standard operating procedures, make sure they have the right material to be able to lessen the stress at the site of the accident, and also to train them ahead of time so that they will have less stress because they know what to do. The other thing we need to do, or you need to think about doing, is select a person in the company to be the contact person for the driver and the insurance companies and the insurance companies' attorneys, as well as anybody else. In other words, here you would want to have someone designated as a spokesperson that gives all information. No matter how severe the accident is, you would want this person to be the conduit of all the information. You would want this person to be able to communicate to anybody necessary here, but only that person. You don't want to make other people involved, whether it is the driver or a mechanic or any other personnel, without first having it cleared through, arranged for, and done by that person. We need to discuss with this person on a regular basis their responsibility and the procedures that they have to take when a crash happens. And so again, to keep that person current and alert. As you change personnel in the office, this person might change, so there needs to be a file developed or a system developed so anyone who now has moved into this position will be updated as to what is provided here. Again, prepare before the event happens is a key to this. The other element here is not all crashes are the same, because some of them, the FMCSA, they don't use the term accidents, they use the term crashes. The crash with the following factors are what will be considered. If the crash leads to someone's death, either the driver, the occupant of motor vehicles, or other third parties' death, that in the term of the FMCSA is a fatality. Second one, it leads to someone being injured seriously enough to have treatment away from the accident site. Again, driver, occupant, or some other person who was involved in the accident. And third, one or more of the units involved in the crash cannot be removed under their own power. That is a towed accident. The FMCSA currently makes no distinction on whether the motor carrier's cause contributed to the crash or not. The FMCSA does not distinguish or care currently about who is at fault or not. If one of these three damages occurred, someone was killed, someone fatality, someone needed medical treatment away from the accident site, injured, or one or more of the vehicles had to be towed, then this is a DO recordable accident. And additional record keeping is required, and possibly post-crash drug testing might be required. We're going to look at depth in both of those areas, but again, these crashes need to be treated separately, and these files or these requirements that are imposed upon a motor carrier by the FMCSA must be met, or at time of a lawsuit there could be more liability placed on the motor carrier, not for what they did, but for what they didn't do, and that is keep these records current and meet the requirements of drug testing and other elements. During this session, we'll look at actions needed depending on what is damaged or injured, how much damage or injury occurs, and also if it's a DO recordable or not. But let's start with the standard operating procedures, the SOPs. Pre-crash planning. Develop a checklist. Provide the list to the driver and a copy in the unit. In this case, I suggest it to be done in a laminated form and easy to be found. Train the driver on crash avoidance. This is the best investment you can make. Monitor and reward the driver for their defensive driving habits. Just as a note, cost of a crash based from a J.J. Keller publication, Accident Report Guide for 2013, for a tractor-trailer combination, a crash with injuries costs per crash $197,679. If the motor carrier has a 3% return of profit on their revenue, then a motor carrier would have to generate $5 million worth of revenue to pay for this one crash. Granted, most of y'all would have this placed into an insurance carrier. The insurance carrier would step up and have to meet these costs, but even then, eventually you would pay. So what we suggest here is do everything possible to keep the driver from having this crash. Monitor their operations, driving within the speed limit, driving within hours of service, and all the new technology that's available to you to control their own road activities will help prevent crashes and will in the long term save a motor carrier a lot of money. But even with all of these things, no matter how much prevention, crashes do happen. And so that's where we're going to spend the balance of our time, is looking at the crashes that they do happen. Train drivers on post-accident activities. No one likes to think about bad things, but crashes happen, so be prepared. The motor carrier insurance provider can assist with this process. Strongly recommend you having your insurance agents, if you're a motor carrier, and your insurance companies involved in this. If you're a provider of insurance listening here, then you need to share this information with motor carriers you insure. In other words, prepare themselves for these events that, when they happen, to lessen the stress and eventually lessen the cost. So if you are a motor carrier, ask your insurance provider for assistance. If your current insurance provider can't or won't give this assistance, then select one who will, no matter how small you are. The information and the material that can be provided by your carrier goes a long ways in making the accident less stressful and cost less dollars. Crash happens. What now? So now we have the crash site, and we visualize, if you would, this crash site. So let's talk about what the driver needs to do. If the driver is coherent, meaning he or she is not injured, that they are cognate, that they're able to walk around and control the site, then the driver needs to do the following. First, and as quick as possible, place all safety warning devices out. Secure the scene. To be able to do this before the trip, make sure all devices are in the vehicle and in good working condition. This means not cracked. This means secured in the location. This means the fire extinguishers have been kept current. Those are the items there. And second, make sure the driver knows how to properly place the devices. Later in this presentation, we have some suggestions how to do this, but let the driver know how to do this. I just had a call from an attorney involving a crash in this way, and part of the liability that is being alleged is that the driver did not place the safety warning devices out, quote, as soon as possible, therefore causing a third party to later be involved in the crash who did not see the trailer that still was protruding on the highway. So this needs to be done first, and if the driver is able to do it, that's the first and foremost requirement. Second, and again, contact the police. Call 911 on your cell phone or other. Again, if the driver is cognizant able to do this. Yes, no matter what and how little damage is done, you want to call 911. Even if drivers or other parties don't want to involve the police, they still need to be called. If there is another vehicle or damage to others' properties at person, this is the key to this. So if the other than your motor carrier's vehicle itself, if that's the only entity that's damaged, no property or no person, then maybe not. But if there's property and persons of others that are damaged, then you need to call 911. I cannot tell you how often it has come back to us in the insurance industry where they say, well, we don't call the police, we don't want them here, that's okay, and then somewhere a month, weeks later, there is a lawyer that sends a letter to the motor carrier and says, you hit this vehicle at this time and this person is damaged. And without an accident report, without a police involvement, without the police knowing about it, we're starting already behind the investigation curve by not having that. So always call the police 911. Second, report the crash to either the main office or to the insurance company. Possibly both. In other words, the main office might be the conduit to report it to the insurance company, or the driver should report it. Again, as soon as possible, as soon after they call the police, so that that's investigated. The more damage is done, the quicker that should be called. And a lot of insurance providers in this marketplace will be able to send assistance to you if the crash is severe enough and bad enough to assist you at those sites. So to this, the driver needs to have with them in their possession the phone numbers to be called and the contact people. And this is again something that needs to be prepared before the accident. So our suggestion here is to have in the vehicle a laminated card that says, in case of an accident, please call the phone number of the motor carrier or the insurance company, the contact person there, and if it's insurance company, the policy name, and then say, please provide the following: the motor carrier's name, their DOT number, the unit or serial number involved, and those things should be on the call already. Then you would want to add in there the location of the accident, the driver's name, and a brief and accurate facts of the event. Just the facts, not the detail and not what happened. For example, here you want to say how many people could be hurt, or there were people, or there were ambulances involved, there were records involved, but don't say as far as the roads were slick, it was raining, where I did not see the vehicle in front. Those facts you do not want to relay until afterwards. This is for the driver, if able, or other police, EMS personnel or others, or someone to call the accident in to the insurance carrier or to the motor carrier, so the motor carrier's personnel can properly pass it on to the insurance carrier. This needs to be done for all crashes involving damage to other people's property or people, their body injuries to other, or fatalities to other people. So, also at accident sites, the do's and the don'ts. Drivers don't, after the report, or do's, after reporting the accident, then provide assistance to others if needed and able. Secure, again, the accident site. Take pictures if able with your cell phone or others, but when you take the pictures, don't focus or don't look at the blood or injuries. You want to look at the bigger view so that later when this accident, if it is severely damaged, we can get accident reconstruction personnel here are able to see what happened. Things like skid marks and slides on the side of the road, and those things are very important. Other vehicles are very important, but don't focus on the blood, don't focus on the gore, focus on what is involved in the layout of the vehicles involved in the accident. So later, if we have to, if the insurance carriers find it necessary to have accident reconstruction people involved, they have this information to help them do this. Drivers don't make any statements about what happened. Never say, "I'm sorry, I did not see you, I fell asleep," etc. One of the situations I had on the accident that was called into me this week concerning the not putting the devices out properly, the driver said, "Oh," to the person they hit, "Oh, I'm sorry, I fell asleep." Those things you do not want to state. You do not want to make any kind of comments about anything that concerns the driver's actions that were taken. Don't talk about the crash at the crash site to anyone but the officer, not to anyone hurt, not to witnesses or anyone else. Only the officer who when they arrive to investigate. This is extremely important. I know it's sometimes against personal emotions where you want to say, "I'm sorry, I hope you're not hurt," things like that. You don't want to have this, and this needs to be a trained situation, not just a one that, because it is against their nature. When dealing with the officer, if asked to make a statement, then do so. But again, just the facts. What happened, but not "I lost control, my brakes did not grip, my steering wheel was loose, I fell asleep," not things like that. But what happened is I hit that vehicle, or I saw the vehicle in front of me and I tried to avoid them, things like that. Those are what you want to do. You do not want to put or imply any mechanical difficulty or driver errors involved in this, just the facts that happen. You do have to answer all the questions, but again, don't elaborate. Again, just what is asked. You don't need to. They don't need to go beyond that. Be able, or if able, ask for a copy of the report or how to get a copy of the report. Later, this will become important. Your insurance carriers or the lawyers they would hire would also obtain this for you. Look for witnesses. Obtain the names and contact information. But again, here's another suggestion. While taking pictures, possibly take pictures of the license tags of other vehicles involved or stopped because of the crash. This might later help us find witnesses here. So that could be important to find out who's there, not only by their name, but if we have their vehicle description and license plate, it might be easier to find them later. This can become extremely important for us in later defending the claim and investigating the claim. DOT recordable or not. One vehicle crash, the question is, can it be moved on its own power or not? Again, a friend of ours who has done programs with us, Dale Reagan with 10th Street, said as a driver he has seen many times where we pull the fender off the wheel, we keep the vehicle going, we put a tire back on so the vehicle can be moved under its own power and does not require towed. Again, that would keep it away from being a DOT recordable. Same thing with a driver. How bad's a driver hurt? Again, obviously bleeding, concussions, bones broken, we're not talking about here. But if they have a slight twitch in the back or or have a headache, suggested the driver go home or go to a truck stop, rest, and then from there maybe go to the facility later. You would want to offer those medical services, but again, delay that. Proper preparation and action can prevent the accident from being recordable if all that was involved is the motor carrier's vehicle itself and that driver. Again, not a third party involved, but the drivers themselves, and that could be important later in keeping the bookkeeping records that you are required to keep. Control record costs. When you talk to your insurance providers, they will tell you that one of the biggest concerns they have is the accelerations of the record fees and costs. So pre-crash, things you want to develop before the crash happens. You want to have a relationship with preferred record service. This is similar to AAA for motor carriers. There's a lot of the providers out there that can do that. Most of them are good. Most of them will provide these record services and would have preferred or selected record services that have a control of the bills that might be generated for these record services across the country. If you're a motor carrier, your agent or your insurance carrier can help you develop these relationships. They are aware of these things, and some insurance carriers already have some alliances with these record services, but you need to take time to develop those relationships and pay the fees. They're not all that big, and when you have the first case involving a large record bill, you'll see that those monthly fees that they charge are worthwhile. If you're an agent or insurance company listening to this, review the providers. Be able to assist the insured in selecting a service that will be beneficial to them and at a cost that is reasonable for what the services are being provided. Here's a key factor that some motor carriers aren't aware of. Motor carriers have the option to choose who provides record services in most cases. The exception to that is there are a few toll roads that have exclusive contracts but with record services, so you would not be able to do it there, but in most cases you would. So to controlling record services, have a card that can be presented to the officer or used by the driver, again laminated, handle them, that says in case of an accident and a need to have the unit or trailer towed, call the following. Again, the record service, whoever that provider is, and their 800 number there, and with the providing information, the motor carrier's name and the membership number of the motor carrier. That will control this. This is very important. You do not have to accept, in most cases, again, exception for some toll roads, the record service that the officer elects or the one on, quote, rotation, unquote. You have the option to call your preferred service provider, but this needs to be established and in place before the crash. So review, post-crash. Develop standard operating procedures. Have a list of do's and don'ts and train the drivers. Train them on a regular basis. Train them, make sure that they're updated, and make sure they're cognizant of that on a regular basis. Have arrangement with a record service that will provide record services within the territory that you as a motor carrier travel, or as retail agent, help them with the territories that they travel in, so that there is someone to call and there will be some control of the record bills and the storage bills that might be generated from this accident. Also have a drug testing services that can provide drug testing nationwide. We'll talk in a few minutes about the requirement of drug testing for a DOT recordable accident, but that also needs to be in place. Have a list of phone numbers and contacts in each vehicle. Again, suggested to put those on laminated cards, maybe even in a color that sticks out, not just white and black tape, black print on them, and have those cards that are able to put there that says, here's who you need to call to report the case, here's our record service, here's these things, so that the driver doesn't have to think about it, doesn't have to remember it. All they can say is hand to the officer, the personnel, or refer to this card and say, and so they know what to do. For help in putting these together, contact your insurance professionals. At the crash site itself, the safety devices in place as soon as possible. You need to secure the site to protect others who have yet to be involved in the crash to be involved later. This is extremely important, and to do it properly will be a discussion that might come up in a claim time. One of the suggestions in this is once it's secured, take a minute to take pictures to verify it was properly secured. This again could help later if someone who maybe is distracted running down the highway does not properly see the reflectors or the secured areas here and run into them. At least now we have done it right. We have met those requirements. Report the accident to the police. Yes, call 911 no matter what happens, whether the driver wants to get the police involved or not, or the third party that might be hit gets the police or not. If there's damage to other than the motor carrier's unit, your unit motor carrier, if there's damage to anything else, you need to call the police. That's the documentation that needs to be done that will become relevant later and will become important. Don't just leave any accident site. Make sure that that's properly done. Then second, as soon as possible, no matter how small the crash is, report it to the insurance company, either directly, if the 800 number from the driver, depending on the size of the motor carrier, or back to the company contact person who will do it. You'll find dealing with insurance professional and insurance agents, the motor carrier will be held in far less of a problem if the accident is reported and later we have a good result. In other words, nothing is paid out, nothing has happened that will not be charged, quote unquote, against the motor carrier's insurance record. What would be caused and would cause the insurance carrier concern is a crash happens, they don't know about it, and somewhere time later then they find out about it, a week, a month, when some third party makes a claim and says, I was hurt by that truck in this location at this time. Then you have to report that claim, and your insurance company now is behind the curve or timeline to properly investigate. So you want to report it no matter how small so that they're aware of it, again, as long as it's controlled and as long as there's no payout involved in it. This does not go against your insurance record. And again, if it's not reported and later something does come up, then that is a record that is even harder to get around. Drivers, assist others if possible. Take pictures. Full sight. Don't talk to anyone about the crash except the police officer. Don't talk about driver's action to the officer, just the facts. Provide officer information on preferred record services, and then also determine if it's a DOT recordable or not. And part of this, again, is something against some drivers might want to, and this is, did the DOT provide a citation at the accident site or not? Sometimes you might not know that, and so someone back in the office might have to follow up with the DOT officer, and if you do not get the DOT report while it's there, depending on the severity of the claim and how much damage done you want to make sure you get a copy of the officer's name and phone number so that someone can get the DOT report of the accident as soon as possible and determine if there was a citation or not, because later you'll find that triggers the drug testing requirements. So let's now spend a few minutes in the post-crash away from crash site. Have someone in the company who's a conduit of information, and no one else except that person should talk to anyone about the crash outside the personnel of the motor carrier. They're the ones who need to talk about the officer, talk to the driver. They're the ones that would talk to a third-party officer or someone else. You would never want to talk to an attorney other than an attorney that's hired by your insurance carrier concerning these. They're also the person who's going to be responsible to get the information that's going to be needed to defend this claim. We'll talk about that in a few minutes. But there needs to be someone there that's a sole person to handle all crashes, to be the conduit of all information, that's provided to anyone else about the crash. It could be the owner, if you're involved in it actively, or if you're a larger motor carrier, someone designated for this purposes. And these things should be written out, and we have those suggestions later. Talk to no one except the motor carrier's insurance representative and or the attorney retained by the insurance carrier. In other words, if an attorney calls up, make sure that they are from the insurance carrier. Retail agents, you can help the insured in this area because a lot of times you will be a conduit of this information to the insurance carrier. You need to inform the motor carrier who the adjuster handling the claim at the insurance carrier area. If the insurance carrier sends out an independent adjuster, who that person is, and if the insurance carrier retains a lawyer, who that lawyer is, so that the motor carrier is comfortable talking to those people, but no one else. Company, communicate the facts, the good, the bad, the other. One of the things that exacerbate the cost of the claim, one of the things that becomes a problem later is if the motor carrier has some information that is adverse to the accident site or adverse to the driver or to them, and do not divulge that up front early as possible. The insurance carriers we're dealing with and the lawyers that they are retaining are trying to look at what the extent of the possible liability that they have. And the more information they have, the sooner and as soon as possible, the better they can make those determinations. So be truthful with all the facts, whether good or bad. And you don't worry about the bad. The accident's already happened. It just gives the insurance carriers and gives the lawyers who are representing you, hired by the insurance carrier, more ability to properly handle the claim. The more accurate information as soon as possible, the best. Post-crash off-site drug testing. This is a concern. Arrange for drug testing to perform anywhere that a crash could happen. You have to understand the FMCSA requirements. Type of crashes that require post-crash drug testing. We'll go through that before this presentation is over here. But there is a concern here, and I've dealt with this with retail agents, and this is not only for motor carriers, but also for retail agents. Do you test all post-crash drug testing? Our suggestion is no, you do not want to do that, because anytime you test, those test results could be later subpoenaed and become a part of evidence. You don't want to test unless you have to. You can rely on your insurance company or your agent or your lawyer to determine exactly the testing procedures. But most of I talk to suggest don't test if not required. But if required, always test. This is a major concern. And only test for the required drugs that are required for the FMCSA. I know that some of you might have work comp carriers. I know some of you might have other people involved in here who have a system or even, quote, a drug-free workplace that says we test all post-injury drug testing. I would make the exception here. You do not want to do that in an auto accident unless required by the FMCSA, which would start with, is it a recordable accident? So my thought is only test when required by regulation and only for the required drugs. Part of this, and this is a key consideration for the personnel in the office, again, preservation of the records, quote, evidence. Don't destroy any records without advice of your attorney or the insurance carrier. You need to have persons assigned to deal with the crash, and all information, including the preservation of records, would be their requirement. Immediately when a crash happens, again, the degree of severity, so when I took the term immediately, the more damage done, the quicker this needs to be done. You need to retain all the records of anybody involved in the accident, from the driver qualification file to their hours of logbooks, to any other discipline actions that you might have, to their MVRs concerning that. For the vehicles themselves, you want to keep a copy of any maintenance records. You want to keep a copy of the DOT annual inspections and the daily inspections done by the driver. You need to keep all those things together. If drug tests are required, you need to keep the results of those drug tests, both pre-employment as well as the post-crash if required by DOT. What you're avoiding is something called spoilization of evidence. This is a place that plaintiff's attorneys go to try to exacerbate the cost of the claim. And if the records are required to be kept or by the regulation or are demanded by the plaintiff's attorneys, and that demand is reasonable. Again, your attorney will determine if it's reasonable or not, but if the demand is reasonable and the evidence or the records cannot be produced, the court systems might instruct jurors or the judge might have to consider, and this is what goes through their mind. Since evidence is not available, and it should be, it was recorded, requested, it was destroyed, then you must, or I must, consider the evidence would have been detrimental to the motor carrier. So you do not want to destroy any of the records, no matter how bad they are. It's and you want to keep them and preserve them as long as the case is still there. Must keep all records and evidence required by the FMCSA or requested by the plaintiff's attorney in a claim file, again, monitored by the individual and the motor carrier who is responsible for these things. Following, we'll have a list of items required to be preserved. We'll talk about that. A tractor trailer might be a part of this evidence that has to be preserved. This is a consideration. If there are deaths, bodily injury, or a large amount of damage, then the equipment might be material in the crash investigation. The problem here is that the motor carrier needs to make money with this equipment. So you need to get the truck back and need for it to make money, but might need to be preserved. So do not repair or return to service until advised by the insurance carrier or the attorney retained on your behalf by the insurance carrier to determine if the equipment can be repaired or not. So you would discuss with the insurance company. There are two types of carriers or adjusters you might be dealing with. The physical damage. That pays for the damage to your owned equipment. There you would have to determine what it's worth in real dollars, same make, model equipment, several of the condition the vehicle is in. Then they would have the option to pay you to repair or replace, but no more than the limit you purchase in the policy, less whatever the deductible. That's how the physical damage will be adjusted at time of accident, and the records you bring to them concerning the value of the equipment, the condition of the equipment, how recent the tires have been changed, and how recent the engine has been repaired or other repairs done, how many miles on it. Those are the things that will determine how much you will get paid for the equipment or how much will be paid to have the equipment repaired. That's the physical damage coverage. But again, we're talking about the liability. The liability is payment to others for damage to their property or person. They provide first defense to you. The attorney they hire is your attorney. Even though the insurance company pays the bill, this attorney represents you. Anything that you tell them becomes confidential. They do not, if they find out something adverse, they do not tell the insurance carrier. They are your representative and your attorney. And any attorney that's hired by the insurance company on your behalf will tell you this or should tell you this going in. And so that's your person here who's hired by your insurance carrier to defend you, to gather all necessary information, and you need to rely on their instructions of what evidence needs to be kept. If you get a request from another attorney that's not yours for any records or any documents or any evidence, do not send it to those other attorneys. Send everything to your attorney. Let your attorney know what these requests are and abide whatever they tell you. The attorney's obligation is to defend you and the insurance company. And if damage is determined to be your fault, motor carrier, then the insurance company will make the payments as long as there's enough limits there. That's that concern. So first off, know the attorney represents you. When there's an attorney involved in the case, do not talk to anyone else without that attorney's permission and or authorization, and provide no records to anybody else without going through your attorney. And again, realize that they're working for you. So your attorney is hired by your insurance company will instruct you on what they need to properly defend you. The sooner the contact, the better if a lot of damage is done. Remember to have a designated person in the company to be the contact for the attorney. One item might be the equipment that was involved in the crash. If the equipment might need to be preserved, if it is, and that's part of the investigation and evidence, and that's part that's been required by the plaintiff's attorney for the plaintiff's attorney to look at, again, your attorney will give you instruction. Don't fix the equipment. Don't do anything to it. Keep it in a secured location, preserved just like it is when it was removed from the crash site. But what you do need to do is arrange with your liability carrier for payment for loss of use of that equipment. Since that equipment is being preserved to help you defend the case, your insurance carrier has the obligation to pay or reimburse you for your lack of use of that equipment while it's being preserved as a part of this case. So this is not done by your physical damage carrier, this is your liability carrier. So anytime you need to keep the equipment there for defense of the case purposes and keep the equipment in the same condition it was prior or after the crash, then your insurance carrier should be in a position to discuss with you payment to you as a motor carrier for your inability to use that equipment. And so that's a consideration. Again, your attorney will give you instructions of how to do this. We have some information that talks about the post-crash information here that could be useful in this. This is provided by some attorneys that will rely on by the insurance carriers who are members of the Motor Carriers Insurance Education Foundation, and hopefully you'll find some of this information useful to you, and we'll review a few of it right now. For everyone who's attending this webinar, we will send you email after the webinar is over that contains this additional information that you might find useful so that you can help your insurers, your motor carriers to prepare this kind of information, and or if you're a motor carrier to assist you in doing these things. Let's talk about warning devices. This is under Federal Regs 571.125. You can go into the FMCSA webpage, download this, and this will give you the types of equipment that's needed and how to properly deploy the equipment at accident site. I suggest strongly that you do this. This is one of the items that we will email everybody later, but you can go in and do it. You want to make sure the devices meet these requirements. The devices are in good condition. The devices are properly secured in the vehicle and accessible by the driver once the crash happens and the driver knows where they are. Things like fire extinguishers, you want to make sure that they're timed. And then you want to look at how the device is to be placed at the accident site to make sure they're properly deployed so that someone else, people who are not involved in the accident, quote, yet, unquote, can avoid it later. Again, one other suggestion that's not here is once the devices are properly placed and deployed, take pictures of them so that later if this becomes a discussion that were not properly done, you have done it properly. This needs to be placed as soon as possible to avoid others from becoming involved. Again, information about the required device and property placement should be in each unit. So it should be attached to, very simply to it, maybe in the packet where you keep the flares and the triangle reflectors, so that the driver doesn't have to stumble around, they don't have to look at anywhere else, but properly show how to deploy. Retention of records. You'll find this in 382.401. These are the records that are required to be retained by the motor carrier by the FMCSA. And those records will tell you how long you have to keep certain records, logbooks, vehicle maintenance reports, drivers, hiring practices, or hiring files, drug test results, both random and for calls, NVRs, those kind of things. And so you first need to be aware of these time frames to make sure that your record keeping is set up to keep these records properly and for the time that is needed in to meet the requirements of the FMCSA. If you ever get an audit, on-site audit, this will be one of the things that the officer will be looking at, and if it's not properly handled, you could be cited for some of these violations. But be concerned about this, because some of these records have the ability to destroy them or get rid of them after the time frame runs out, but not if the driver or the units are involved in an accident. Even though the FMCSA records say that you can destroy those records, don't do them if the unit or the driver is involved in an accident. These records need to be preserved as long as the possible claim or there's an active claim. Until the claim is settled, until a time frame, these records do not want to be destroyed. The example that I use here that's most commonly done is the logs. You're required to keep logs 6 months, but if an accident occurs, you need to keep at least 60 days prior to the accident. No longer or longer if advised by your driver. Actually, we would want to make that 10 days, not 60 days, 10 days. You just want the relevant trip involved in it, not 60 days, but 10 days. That's how long you want to keep those driving records, not the full 6 months, but you want to keep the last 10 days, or again with your attorney. So once the 6 months time frame is over, it's time that you have FMCSA permission to destroy the logs. You want to contact your attorney and says, I have these logs here. How long of these logs do you want me to preserve for you to keep as a part of defending the case? Part of the accident record that is required for FMCSA, and these records must be kept 3 years after the date of each accident, and the information placed in the register must be contained, or at least ascertain at least the following: the day of the accident, the city and town, the driver's name, the number of injuries, number of fatalities, whether there's a hazmat spill or occurrence or not, and copies of all accident records required by state or other government entities or insurers. This requirement necessitates the need for a folder to be placed these accidents. And best practice contain a separate file for each accident. This is FMCSA regs that for a DOT recordable accident, again, a fatality, injury, or towed must be kept. Post-accident drug testing is 382. That's the regulation. FMCSA requires post-accident drug testing, drug and alcohol testing. The following indications the condition in which the test is required. You refer to your own drug and alcohol policies or FMCSA regulation regarding these completed drug test requirements. They need to be in place, and someone needs to do this. As soon as practical, following an accident involving a commercial motor vehicle operating on a public road in commerce, each employer shall test for alcohol in 2 hours or 8 hours and controlled substance in 32 hours. This applies to drivers with commercial driver's license CDLs, and only if the accident meets one of these requirements. And here's the key of the requirements. If there's a fatality, a human fatality, whether the driver is cited or not, there must be a drug test. So this chart says, yes, if they're cited, you need to be a drug test, but even if they're not cited for an accident, you need to be a drug test. This has nothing to do with fault. The driver could have nothing to be involved in an accident. One of the cases that has come up as one of the examples here is there was a case, the accident happened where the driver was actually in the motel in the bed asleep with his vehicle parked legally, and someone ran off the highway, ran into their vehicle parked legally, and died. That driver in bed must be tested for drugs. I realize that's ridiculous, but that is the regulation, so you need to do that. If there's bodily injury with an immediate medical treatment away from the site, again, injuries. If there's a citation, then they need to be drug tested. If there's no citation, they do not. So that's the key component here. Was the driver cited for anything? That needs to be asked by the driver, the DOT officer by the driver. The DOT report will say that part of it. There's some of them that are underdetermined at the present time. So this is why you need to copy the report. You need to have the driver ask if there's a citation issued or not. Same thing if the vehicle is disabled and has to be towed. If there's a citation, then the driver must be drug tested. If there's no citation, then the driver does not have to be drug tested. So if the drug test possible is not registered in 2 hours following the accident, the employee shall prepare and maintain on file the record stating the reason why it was not done in that period of time. The test requirement by the section is not admissible, is not administrated within 8 hours following the accident. The employee shall cause attempt to administer a drug test and shall prepare and maintain the same records. Records should be submitted to MCIEF upon request. Again, this controlled substance test, other than alcohol, you need to do those in 32 hours. You need to be aware of this. This goes beyond having the DOT officer having the driver walk the white line. This is taking body fluid test or hair particle test. This could be done at a hospital, or if a test such as that is administered beyond just walking a white line with the DOT officer, sometime it will meet this requirement. Again, if it's a DOT recordable accident, a fatality, no matter caused by who, injury away from the site, and the driver is cited for a violation, and one or more of the vehicles involved in it has to be towed, then you must have the post-crash drug testing. The crash we discussed in this section address is involved in the damage to the equipment of the motor carrier and to the public. If the crash happens, there are other areas of concern such as cargo. Cargo and other concerns will be addressed in future presentations. If you need additional information, we will email all attendees additional information with more details as far as the record keeping, what's required to help you prepare personnel and drivers for these things. The information along with a recording copy of this presentation will be available on our website, which is transportationriskspecialist.com here. And for those who are not yet members of this, whether you're a motor carrier or an insurance professional, there is a possibility for there is a 30-day free trial on this area to be aware of this. If you're a motor carrier, we are here to provide you this information. So for further information about the Motor Carriers Insurance Education Foundation, Transportation Risk Specialist, and how we can help you if you're a motor carrier, again, send us an email at trs@ibci.net or call our 800 number, 800-741-4084. We thank you for your attention. We hope that you will find this beneficial. We'll remind you again, this is an unpleasant subject, because no one wants to have a crash, but if a crash happens, and they do happen, the better prepared you are, the better results it will be. This is Tommy Ruke on behalf of the Motor Carriers Insurance Education Foundation and the Transportation Risk Specialty Education Program. We're finished. Thank you very much for your time and your attention.